In this video, we will make an attempt to understand the power and the procedure relating to the amendment of the Constitution of India. These provisions are contained in Part 20 of the Constitution with the caption Amendment of Constitution. The concerned article is Article 368 and it is captioned as Power of Parliament to amend the Constitution and procedure therefore. So there is only one article which deals with the power of Parliament to amend the Constitution. It also contains the procedure for the amendment. Let us first see the bare provisions of Article 368. This article has 5 clauses. Originally, there was only one clause in this article. Then 2 clauses were added by the 24th Amendment in the year 1971, and 2 more clauses were further added by the 42nd Amendment in the year 1976. Let us first see the first clause of Article 368 in the way it is presented in the Constitution. I'll just read it and then explain it. Notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. Now, in the next slide, we will see the same provision in a simplified form. I have given it the heading of source of amending power. So we can say the first clause of Article 368 contains the source of the amending power. In exercise of its constituent power, Parliament may amend any provision of this Constitution, and then there are 3 methods by which it can be so done, either by addition or by variation or repeal. And this has to be done in accordance with the procedure which is laid down in this article itself, in the very next clause. However, the important thing to note here is that this power of the Parliament to amend the Constitution is to be characterized as, is to be known as the constituent power. And it is to be distinguished from the legislative power of Parliament. The ordinary lawmaking power of Parliament is known as the legislative power, whereas the amending power is known as the constituent power. And then this power is given only to the Parliament and to no other authority. And then it says any provision of this Constitution. So it's clear from this provision that there is no limitation. Any provision of the Constitution, any and every, can be amended. So from here we find that Parliament is the sole authority as far as amendment of the Constitution is concerned. But then it says that it has to be done in accordance with the procedure. So where is the procedure? Procedure for amendment. It is in fact given in Article 368 Clause 2. What we see on in this slide is the language as it is written in the Constitution. However, we can simplify it in this way, and we can put a caption, amending procedure, as far as Clause 2 is concerned. So this is Article 368 Clause 2, captioned as amending procedure. And then the procedure is divided in 3 parts. The first part is initiation of amendment. This is to be done by introduction of a bill, and the bill can be introduced in either House of Parliament. So as far as amendment of Constitution is concerned, a bill can be introduced in either the Lok Sabha or the Rajya Sabha. Both houses have same power as far as introduction of the bill is concerned. The second step is passing of the bill by each house. So the bill has to be passed by each house, and with what majority? The majority with which the bill has to be passed comprises of 2 components. The first component is a majority of total membership of that house. And the second component by a majority of not less than 2/3 members present and voting. And in between, there is the word "and", which indicates that both these conditions have to be satisfied. That is, for passing of the bill in each house, and the bill has to be passed in each house separately. There is no provision of a joint session. So each house has to pass the bill separately, and each house has to pass the bill with this specified majority, which is in two components: majority of total membership of the house and a majority of not less than 2/3 members present and voting. Once this is done, the bill is sent to the president for his assent, and the modified provision says that the bill, when it is presented to the parliament, to the president, he shall give his assent. And then the amendment happens. This is the procedure. However, there is a proviso, and that proviso specifies a different procedure in respect of certain provisions of the Constitution. Let us see which are those provisions and what is the procedure in respect of those provisions. These are the bare provisions as they appear in the Constitution, these two slides. However, I intend to go straight to the simplified version as we present it before you. We say the caption of this slide is ratification by state legislatures. This is the special procedure to be employed in respect of certain provisions of the Constitution. Let's see what it says. An amendment requires to be ratified by not less than 1/2 of state legislatures before it is presented to the president for assent. It seeks to make any change in the following provisions. So there are 5 types of provisions. Any amendment to these provisions requires this special provision, and this special provision says that before the bill is presented to the president for assent, which means after it is passed by both houses of parliament, but before presenting to the president, the bill has to be sent to all the state legislatures, and it needs to be ratified at least by 1/2 of state legislatures before it can be presented to the president. Now, what are those provisions which require this special procedure? First category of special of the provisions is Article 54, 55, 73, 162, and 241. These 5 articles have been specifically named, and any amendment to any of these 5 articles will require this special provision. 54 and 55, we will recall, relate to the election of the president. 73 and 162, these 2 articles deal with the executive power of the union and to the state respectively. And Article 241 deals with establishment of a high court in a union territory. The second category of provisions relating to judiciary and distribution of legislative powers. You will recall that provisions relating to judiciary are available in Part 5 of the Constitution as well as in Part 6. Part 5 deals with the Supreme Court, Part 6 deals with the High Court and subordinate judiciary. And all these provisions, if any amendment is to be made in respect of provisions relating to the Supreme Court, in respect of provisions relating to the High Court and subordinate courts, and then distribution of legislative powers, which is contained in Part 11 of the Constitution, dealing with the lawmaking power of the Parliament and the state legislatures. If any amendment is to be made there, then also this special procedure has to be adopted. Similarly, if any amendment is required in any of the 3 lists in the 7th schedule, the union list, the state list, and the concurrent list, then also the same procedure. Representation of states in parliament and provisions of Article 368, that is this article. So if any change is to be made in this article, then also ratification by state legislatures will be required. So this is the special provision, and these are the provisions which require this special procedure. Now we can change our previous slide where we had said that Parliament is the sole authority to amend the Constitution. Now we'll modify it in this way that in most cases, Parliament has the sole authority to amend the Constitution. No other authority needs to be referred to. But in some special cases, an amendment passed by Parliament has to be ratified by at least half state legislatures. And please note that it is not more than half of the state legislatures, which is what we call as majority of state legislatures. It is slightly less than that. Just half will be sufficient. Now let's deal with a very important issue which has engaged the attention of the Parliament as well as the Supreme Court right from the beginning. And this question has been put in this way: whether fundamental rights could be taken away by Parliament by constitutional amendments. Fundamental rights are contained in Part 3 of the Constitution. The question here, the issue here is whether any of these fundamental rights can be taken away, can be amended, can be curtailed by the Parliament by way of constitutional amendments. This issue was first, let us first see what is the protection available to fundamental rights. Why are we putting this question? What is the protection available to them otherwise? The protection to fundamental rights is contained in Article 13. For our purpose, Clause 2 is relevant, which says, state shall not make any law which takes away or abridges rights conferred by this part. So there is a complete ban. There is a complete prohibition to the state. It will not make any law which takes away or abridges, even curtails any of the rights conferred by Part 3. And as far as this article is concerned, and then it further says that if any such law is made by the state, then it shall be void to the extent it takes away or abridges these rights. This article declares, without anything else, it simply declares as void all those laws which are made by the state which have the effect of taking away or abridging any of the fundamental rights as contained in Part 3 of the Constitution. And for this purpose, the definition of law has been given a wide meaning. Article 13, Clause 3 says law includes ordinances, orders, bylaws, rules, regulations, notifications issued by the executive authorities, and then customs or usages having force of law. And of course, the ordinary meaning of law, that is the law made by the legislature, is definitely included. It's an inclusive definition, so the scope has been widened. With this definition of law in mind, and with the protection given to the fundamental rights as contained in Article 13(2), let us see how the constitutional law has evolved on this issue. We are now looking at development of constitutional law on Article 368 vis-a-vis Article 13. Article 13 gives protection, and Article 368 gives power to Parliament to amend any part of the Constitution. So there is an apparent contradiction between the two. Let us see how this unfolds. The first stage, the Supreme Court had a look at this provision in the very well-known case of Sankari Prasad versus Union of India, decided in the year 1951. In this judgment, the Supreme Court held thus: the word law in Article 13(3) did not include amendments under Article 368, and thus Parliament could amend any of the fundamental rights by way of a constitutional amendment acting under Article 368. So in this case, I am again showing you the name of the case, Shankari Prasad versus Union of India, 1951. And it very clearly says that Parliament had the power to amend any of the fundamental rights, not by ordinary laws, of course. That protection is available under Article 13, Clause 2, but by way of constitutional amendments when the Parliament acts under Article 368. This was the initial interpretation, original interpretation given by the Supreme Court to the power of Parliament under Article 368. In this judgment, it was further held that there is a clear demarcation between ordinary law, which is made in exercise of the legislative power, and the constitutional law, which is made in exercise of the constituent power. The constituent power is available under Article 368, and this law was characterized by the Supreme Court as constitutional law, and it has said that there is a clear demarcation between the ordinary law and the constitutional law. The terms of Article 368 are perfectly general and empower the Parliament to amend the Constitution without any exception whatever. This was the categorical finding given by the Supreme Court in 1951. The Parliament had the power to amend the Constitution without any exception whatever. So any and every provision of the Constitution could be amended by the Parliament. This was the initial interpretation. And it was further said that in the context of Article 13, law must be taken to mean rules or regulations made in exercise of ordinary legislative power and not amendments to the Constitution made in exercise of the constituent power. So a differentiation has been made between the ordinary legislative power and the constituent power. There are restrictions to the ordinary legislative power, but there are no restrictions to the constituent power. However, in 1967, an 11-judge bench of the Supreme Court had another look at the same provisions in the case of Golaknath versus State of Punjab. Golaknath versus State of Punjab, 1967. This is stage 2 of the development of constitutional law on this subject. In this judgment, let us see what the Supreme Court said. The first thing, the Supreme Court overruled its decision of 1951 in the Shankari Prasad case. So the case which we have just now discussed, the findings given in that judgment has been specifically overruled, and overruling that judgment, in Golaknath's case, the Supreme Court held that Parliament could not take away or abridge the fundamental rights even by constitutional amendments. Parliament could not take away or abridge the fundamental rights even by constitutional amendments. The decision is this: by a thin majority of 6:5. As I said, it was an 11-member bench, and by a thin majority of 6-5, it held that a constitutional amendment under Article 368 was an ordinary law within the meaning of Article 13(2). If it's ordinary law, then the protection of Article 13(2) will definitely come into picture, and it will prohibit any abridgment or any taking away of any of the fundamental rights contained in Part 3. In this judgment, the Supreme Court said that there was no difference between ordinary legislative power of Parliament and the inherent constituent power of Parliament to amend the Constitution under Article 368. Now they are saying there is absolutely no difference between the ordinary legislative power, ordinary lawmaking power, and the constituent power of Parliament available under Article 368. And that's why we say that there is a complete overruling of the Sankri Prasad case in Golaknath's case. Constitutional amendment, also being an ordinary law within the meaning of Article 13, could not be in violation of fundamental rights. And if it falls in under Article 13, obviously, then it cannot take away or abridge any of the fundamental rights. This is the finding in Golaknath's case. Now, this completely took away the power of the parliament to amend any of the fundamental rights. So when parliament power to amend the fundamental rights was completely negated, then there came an effort from the side of the parliament, from the side of the executive, in stage 3, to amend the constitution itself, and thus came the 24th amendment in the year 1971. Let us see what it provided. This 24th amendment made two changes, one in Article 368 and the other in Article 13. Now, the change in Article 368 is this, that a new clause was added, numbered as 368(3), and this is the provision. Nothing in Article 13 shall apply to amendments under this article. So, it's a very far-reaching amendment. We said that whatever is written in Article 13 regarding protection given to fundamental rights, that protection which has been given by Article 13 will not be available to amendments made under Article 368. In a very clear and unambiguous language, this is what the Parliament provided in Article 368 itself. And a corresponding change was also made in Article 13 by way of addition of a new clause, number 4, which said that nothing in this article shall apply to amendments under Article 368. Both are saying the same thing, and this is what the Parliament provided, thereby empowering itself to amend any of the fundamental rights while acting under Article 368. Mind it, it is not when it is acting as a legislative body, this power is available only when it is acting as a constituent body and exercising its constituent power. But this amendment was challenged before the Supreme Court and thus came stage 4 in the shape of Case Anand Bharati versus State of Kerala in 1973. A very celebrated case, Case Anand Bharati versus State of Kerala, 1973. Constitutional validity of the 24th Amendment of 1971 was challenged in this case, and the Supreme Court clearly upheld the validity of the 24th Amendment. As far as the amendment is concerned, the Supreme Court said, yes, it's valid. Now, what is the effect of holding the amendment as valid? The effect is that the Parliament gets the power to amend any of the fundamental rights. And if this power is to be upheld, then what happens? The Golaknath case, which had held that fundamental rights were beyond the amending power of Parliament, had to be overruled, and it was duly overruled in this case. So you will see the development. 1951 came the Sankri Prasad case, which was overruled in the year 1967 when judgment in Golaknath's case was delivered, and this in turn was again overruled in 1973 when judgment in the Case Anand Bharati case was delivered. The Supreme Court has twice overruled its own finding on this matter. Now you can understand how sensitive and how important this issue has been. So this meant that the fundamental rights could be amended by the Parliament. Clear meaning of upholding the constitutional validity of the article of the 24th Amendment. And then there was a provision, an interpretation, which changed the shape of things. So there was a but. And let's see what that but is. The question which was posed before the Supreme Court, are there any limitations on the amending power at all? If we say, or if the court holds that the fundamental rights could be amended by the Parliament while acting under Article 368, then are there no limitations at all on the amending power, or are there still any limitations on the amending power? This question was answered by the Supreme Court in a novel way. If we say the literal interpretation, as we see Article 368 Clause 1, it's clear from there that that clause does not put any limitations whatever on the constituent powers of Parliament other than prescribing a special procedure of ratification by state legislatures in certain specified cases. So that is the literal meaning or literal interpretation. However, interpretation of the Supreme Court was thus, and this is very important. This is the crux of the judgment. The judgment in case Madan Bharti versus State of Kerala said certain provisions of the Constitution form its basic structure. Certain provisions, and these provisions are not exhaustively specified in the judgment, mind it. That is why the word used is certain. Certain provisions of the Constitution, some provisions of the Constitution form its basic structure, which are not amendable by Parliament by exercise of its constituent power under Article 368. A clear-cut mandate given by the Supreme Court is that those provisions of the Constitution, and without specifying exhaustively as to what those provisions are, the Supreme Court simply said that there are certain provisions which cannot be amended by the Parliament even under Article 368. And what are those provisions? Those provisions have not been exhaustively mentioned in the judgment. So it remains an open question all the time. Let's see further. What is the impact? The Supreme Court of India came up with this novel new limitation in 1973 while propounding the basic structure doctrine in case Madan Bharti versus State of Kerala. Basic structure doctrine, as it is called. This happens to be the single most important judgment in India's constitutional law history. It was given by a 13-judge bench by a 7-6 majority, and it was delivered on the 24th of April 1973. The date is important because it acts as a cutoff date for certain aspects of constitutional law, which we will see at an appropriate time while the validity of laws contained in Schedule 9 are considered. So this judgment was delivered on the 24th of April 1973. The date also needs to be remembered because it acts as a cutoff date. The principle here is the theory of basic structure. Now, the next question is what comprises the basic structure? As I explained earlier, this has not been exhaustively defined. However, in this very judgment, it was said that the basic structure may be said to consist of the following features. Certain features are mentioned here. I'll just show you the features as they appear in this judgment. 5 of them are mentioned here. So these should be specifically noted and remembered. Supremacy of the Constitution is a basic feature. Supremacy of the Constitution. Republican and democratic forms of government. Secular character of the Constitution. Separation of powers between the legislature, the executive, and the judiciary. The federal character of the Constitution. Supremacy of the Constitution, secular character, federal character. These three things. Then form of government, it is republican and democratic, and then separation of powers. These were specifically mentioned, and then, as I said, it was an open issue. It was kept open to be decided, and then when the situation